Welcome to EU Privacy for All, Session 28 on GDPR, Communication of Data Breaches to Data Subjects, Article 32. On the communications of data breaches to data subjects, European Parliament stressed notably 2 points. First is the fact that such a communication should be implemented whenever the rights or legitimate interests of the data subject would be impacted. And second, that this communication shall be comprehensive and use clear and plain language. On its side, EU Council stressed the fact that only breaches resulting in a high risk should be communicated to data subject, such as discrimination, identity theft or fraud, financial loss, damage to the reputation, unauthorized reversal of pseudonymization, loss of confidentiality, or any other significant economic or social disadvantage. Other points stressed by the Council were about the fact that the communication shall not be required if appropriate technical and organizational measures were taken by the controller, or when high risks triggered by this breach were mitigated by the controller, or when such a communication would involve disproportionate effort. All those suggestions were retained in the final draft. The latest on adversely affecting a substantial public interest was not retained. As previously stressed, Article 32 retains lots of proposals from the Council, so notably the fact that communication to data subjects shall be implemented whenever the breach is likely to result in a high risk. Second, from EU Parliament side, the fact that this communication should describe in clear and plain language the nature of the breach, notably including the name and contact details of the DPO or of the contact point, the likely consequences of the breach, and the measures taken to mitigate the consequences and adverse effects of this breach. The communication shall not be required for the 3 conditions proposed by EU Commission, that is to say, the fact that appropriate technical and organizational measures were taken, or the high risks were mitigated, or it would involve disproportionate effort. In such a case, the controllers shall instead grant a public communication or a similar measure whereby the data subject would be informed in an equally effective manner. Finally, the supervisory authority, having considered the likelihood of the breach to result in a high risk, may require to data controllers, if not done, to communicate the breach to the data subjects. A key provision in GDPR is Recital 67A. It explains that a high risk for the rights and freedoms of individual justifies notification to data subject. Other provisions, such as Recital 68, frame the nature and gravity of the personal data breach and its consequences and adverse effects for the data subject. If not assessed correctly by the controller itself, it may result in the intervention of the supervisory authority, constraining the controller to communicate data breach to the data subjects concerned. Other provisions on the likelihood of breaches and their impact on data subjects might be interesting. As stressed regarding the notification of breaches to supervisory authority, codes of conduct on data breaches, investigative powers of supervisory authorities, and European Data Protection Board guidelines, recommendations, and best practices on notification and on the assessment of high risks for the rights and freedoms of the individuals are also framed in the GDPR. Currently, the directive does not frame data breach communication to data subject. However, Article 10 and 11 on information of data subject, whether they do provide directly personal data to the controllers or not, mention that any further information shall be provided to data subject in order to guarantee fair processing in respect of the data subject. What should accountable data controllers and processors get prepared for? Controllers will have, without undue delay after becoming aware of it, to communicate the breach to the data subjects when this breach is likely to result in a high risk for the rights and freedoms of those data subjects. Controllers will also have to describe in a clear and plain language the nature of the breach, providing at least the name contact details of the DPO or of any contact point, the likely consequences of the breach, and the measures taken to mitigate the consequences and adverse effects of this breach. The communication will not be required if appropriate technical and organizational measures were taken, if the high risk for the rights and freedoms of data subject is no longer likely to materialize because of the measures taken by the controller, if the effort required is disproportionate. In such a case, a public communication could be equally effective. The use of codes of conduct on data breaches might be recommended, and DPA's orders on communicating breaches to data subjects should be anticipated. EDPB guidelines, recommendations and best practices on what is undue delay, what are disproportionate efforts, and what constitutes a high risk will be an added value to dig into and know more about.